Welcome to this explainer. Look, if you're an adult child suddenly tasked with managing a parent's medical emergency, it's incredibly stressful. You're exhausted, you're navigating complex, crazy healthcare decisions, and frankly, you're probably terrified of losing your family's entire life savings to long-term care costs. It's a massively heavy burden to carry. But hey, you're in the right place. Today, we're going to take a breath, step back, and look calmly at the facts.
Okay, let's dive into this. I know your cognitive bandwidth is practically zero right now, but you don't need to be a legal expert to get through this. Here is your crisis roadmap. We're going to quickly hit the urgent Medicaid crisis, the rules of the game, protecting the community spouse, saving the family home, caregiver agreements, and finally, your exact crisis action plan.
First up, the urgent Medicaid crisis. So, what actually happens when you're suddenly given, say, exactly 48 hours to find a nursing home? It is a brutally jarring transition. You go from a relatively manageable Tuesday right into a frantic placement deadline. Families are left scrambling, and they're usually completely unprepared for the financial reality waiting for them the literal moment they walk through those facility doors.
And here is the financial monster you're staring down. In states like Ohio, nursing home costs range from $7,000 to over $10,000 every single month. Without Medicaid, that massive burden falls squarely on your family's shoulders. It's a staggering expense that can instantly evaporate a lifetime of hard-earned retirement savings. Without a game plan, the money simply vanishes.
All right, Section 2, the rules of the game. Because understanding Medicaid eligibility, that is absolutely your greatest advantage right now. Now, there are basically two types of asset protection. First is proactive planning. That's what you do using irrevocable trusts when your parent is totally healthy. But let's be real, you're probably in crisis planning mode right now. Your parent is already in a facility. And while proactive planning gives you more options, crisis mode still offers highly effective, perfectly legal strategies to save their assets. Seriously, it is not too late.
But you got to be aware of a major constraint, the 5-year look-back period. Under the Deficit Reduction Act, when you apply for Medicaid, the government strictly reviews any, and I mean literally any asset transfers made up to 60 months prior. If you just blindly transfer your parents' house into your name, or if they just gift you their money thinking it'll hide it for Medicaid, no way. You will trigger devastating penalty periods that completely delay their eligibility for care. Whatever you do, do not make unguided transfers.
So the crucial point here is this. Crisis planning is not about hiding cash under a mattress. It's about using the established Medicaid rules lawfully, strategically, and quickly to prevent a total financial collapse for your family. If you play by their rules, you can win.
Moving to Section 3, protecting the community spouse.
If one parent needs a nursing home, it is absolutely crucial that we ensure the healthy parent, the community spouse, isn't left destitute. Decades ago, Congress realized this and created the spousal impoverishment rules to act as a legal shield. The Community Spouse Resource Allowance protects a huge portion of the couple's savings. Meanwhile, the Minimum Monthly Maintenance Needs Allowance ensures the healthy spouse keeps enough income to actually survive with independence and dignity. Plus, there's a personal needs allowance, so the spouse receiving care is protected too. Now, this process is officially called the post-eligibility treatment of income. I know it sounds like a mouthful of dense legalese, but here's what it actually means for your mom or dad. Before all of the institutionalized parent's income is handed over to the nursing home, money is cleanly deducted to pay for the healthy spouse's living allowance, certain family allowances, and necessary medical expenses. The facility only gets paid after those protected amounts are subtracted.
All right, Section 4, saving the family home.
For most adult children, this is usually the single biggest worry, right? Losing the house. Well, under the Deficit Reduction Act of 2005, Medicaid won't pay for long-term care if a person's home equity exceeds a certain limit, usually somewhere between $500,000 and $750,000. But the law also built in some absolutely incredible exceptions.
Get ready for a massive sigh of relief here. If your parent goes into a nursing home, Medicaid cannot force the sale of the house. They can't even place a lien on the property if any of these specific relatives are currently living there. If there's a spouse residing in the home, a child under 21, a blind or disabled child of any age, or even a sibling with an equity interest who's lived there for over a year, the home is completely protected.
On to Section 5, Caregiver Agreements and Proof.
So, what if you've been making intense personal sacrifices to care for your aging parents at home? Well, there's a highly tactical strategy designed exactly for you, a caregiver contract. This is a formal legal agreement that allows your parent to legitimately pay you for essential care services. Because it's a fair market exchange, it legally reduces your parent's countable assets without triggering that devastating 5-year transfer penalty we talked about earlier.
Now, what's really interesting is this legal hack for adult children in states like Ohio. If you lived in your parents' home for 2 continuous years immediately before they went into a nursing home, and your care actively delayed their institutionalization, the title to the home can actually be transferred to you, 100% penalty-free. But listen, documentation is absolutely everything. You have to complete the specific child caregiver affidavits, prove your services, and, crucially, get a physician's certification proving your care kept them out of the facility.
Which brings us to Section 6, your Crisis Action Plan.
We've covered the rules and the protections, so let's move to the action phase and see how this all builds together. Here are the rapid-fire, lawful strategies you can deploy right now. You can legally spend down cash by making necessary home repairs, which converts countable cash into an exempt home asset. You can pay off legitimate credit card debts, prepay funeral arrangements, or even use Medicaid-compliant annuities and promissory notes to protect up to half of the remaining assets.
But hear me on this. Attempting to manage this whole process independently while you're dealing with emotional upheaval, it's incredibly dangerous. Just one misstep on a promissory note, one unnotarized affidavit, or one badly timed transfer can trigger massive penalty periods, which means an outright Medicaid denial. DIY is simply not an option here. You really need an experienced elder law attorney in your corner immediately.
So, that leaves us with one final question. Will you try to navigate this crisis alone and risk losing everything to the healthcare system? Or will you use the rules lawfully to protect your family's legacy starting today? Look, you've got the tools. You know the rules exist, and you know there are legal avenues to save your parents' home and savings. It's time to take back control, get the right professional help, and protect your family. Thanks so much for joining me for this explainer.